We do have a new filing in the JGG case for March 28th, which is Friday today. And it's not really that unique of a filing, except I think this really lets us as the public know that this administration and this Department of Justice is struggling with the level of flooding that's going on. Right? They're trying to flood the zone. Everyone's been hearing about that. Well, the thing about flooding the zone is you get swept up in it too. Here's JGG. Here's JGG, and this is the El Salvador situation, lack of due process. And they had they needed to file an opposition to the motion to extend the temporary restraining order by noon today. The plaintiffs had already put in a motion to extend it and, as required by the judge. So again, without getting too far into the weeds of this is one paragraph, everyone, and it's signed by, these doofuses. One paragraph. This is a motion, opposition to the motion to extend, and this is what they have written in here. They oppose the plaintiff's motion for an additional 14 days, looking at the electronic filing, as set forth in defendant's motion to vacate the temporary restraining order here. The court lacks jurisdiction over plaintiff's claims, which challenge matters within the president's unreviewable authority, and nonetheless sound in habeas, and must therefore be brought as a habeas claim in district confinement. Again, another citation. Plaintiffs also failed to show a likelihood of success on the merits, citing the previous filing, and have not demonstrated irreparable harm sufficient to overcome the president's powerful interest in managing matters of national security and foreign affairs. Citing the reference here, and then citing this case here with no explanation of this case law. For these reasons, which are set forth by defendants' prior briefs and incorporated here, defendants oppose any extension of the temporary restraining order. So you might think like, oh my gosh, oh my goodness, everybody, this is not how you draft this is not how an opposition to any motion should ever be drafted, much less actually filed in court. Are you freaking kidding me with this? I mean, are you seriously freaking kidding me? I've got to say, this shows us right here. You've got one paragraph. There is no arguments in here. There is no set of organizations. There's no facts. There's nothing except for references back to things they have already written. So we have this paragraph in a motion saying, well, we oppose it. Well, why do you oppose it? Look at our other stuff. Like, you're not supposed to do that in legal research and writing. It's one thing to do a quick summary of what you've already done and then cite to it. But when you're just putting one sentence and then a citation, and that's supposed to be your argument for an opposition to somebody else's motion, this is lazy. And this could be potentially seen as unethical because you're supposed to do good faith work you're supposed to be doing good faith work when filing things with the court. I have not seen even in legal research and writing courses being taught where they have been so lazy or so lacking of any kind of professionalism that they write just one sentence with no explanation, then cite it, and then submit it to court as an opposition. There's no opposition here. What we have are a few sentences that are citing different other documents. That's it. This is not an opposition. And we have a case that's being cited, but we don't know why. There's no reason to know what they're citing this case for. Like they're citing pages 33 to 35 for what? For what? What's going on in this case? Anyway, so if you are wondering, oh my gosh, they're just flooding the zone, doing everything they want, all of these attorneys are going full on. No, this is showing us that these attorneys trying to defend these cases, they're running on a skeleton crew and they have nothing to stand on. Now they're just putting words on a piece of paper and filing it Now they're just putting words into a document, filing it, and keeping their fingers crossed that they've met the requirements of the judge. This is absolutely a legal abomination, and I would give this an F if I were to be grading it in class.